Alright, class. This is the second element of rules of natural justice known as nemo judex in causa sua, rules against bias. Okay, what is bias? Bias means berat sebelah, unfair. Okay, the authority may reach unfair decisions if does not follow the procedure of natural justice. Okay, rules against bias may be divided into three. Okay, we have pecuniary. Pecuniary means monetary bias. Okay, personal bias. Personal bias will depend on the relationship, and then policy bias. Policy here means that whether the authority will become a substantial part, okay, in drafting the policy. Okay, the first one is pecuniary bias, or known as a monetary bias. When a person here refer to the panel, okay, refer to the authority that has a monetary interest in the case being decided. It does not matter how small the interest is. Okay, so tak penting lah. Okay, banyak mana sekalipun the monetary interest there. Okay, but it still becomes what we call it as wrongdoings under rules of natural justice. As you can see in the case of Dimes against Grand Junction Canal 1852, in this case a public limited company filed a case against a landowner. The Lord Chancellor, who was a shareholder in the company, heard the case. So in this case, the Lord Chancellor become a panel, take note, and he hear the case. And he was also a shareholder and gave the desired relief to the company. So bila dia buat decision, okay, he will make decision in favor of his own company. So the House of Lords squashed the decision because the Lord Chancellor's pecuniary interest in that company. Okay, so of course dia akan protect his own company because dia adalah shareholder in the company. Okay, hope that you understand. Okay, next type of bias is personal bias. Okay, this is when the adjudicator, the authority, the panel has a relationship with the person being tried, either as a relative, a friend, or business partners, etc. The relationship can be a positive one, relatives, friends, or a negative one, enemies, rivals, etc. For example, let's say a husband become a panel in disciplinary boards, okay, and the accused his wife, okay, so the decision later may has a personal bias because of the relationship between husband and wife. Okay, so the same things may be applied here in a disciplinary board of UiTM. Okay, if you want to appoint panel, okay, panel must have no relationship with the students. Okay, the test used in personal bias is whether there is a likelihood of bias, and this is ascertained with reference to the right-minded person. So kita nak tengok akan ada tak bias. Okay, and we follow the reasonable man. Okay, we have one case here. Case of Metropolitan Properties Co. against Lennon, 1968. In this case, the tenants of a flat applied for a reduction of rent, and the application was considered by a civil committee whose chairman was the son of one of the tenants. So the panel here is chairman, and one of the chairman here is sorry, not one of the chairman, one of the panel yang buat decision tu, chairman was the son of the tenants. So when the rent was reduced, the decision was challenged as having personal bias. So of course, sons tu as the chairman, dia akan buat decision in favor of the tenants lah, because tenants is could be his parents. So when the rent was reduced, the decision was challenged. And the court held that there was a real likelihood of bias on the part of the decision maker. So akan ada kemungkinan, akan ada possibility of bias. Okay, so when there was a possibility of bias, when there was a likelihood of bias, personal bias, so the decision letter will becomes ultra bias. And the third one is policy bias. Okay, policy is when a person sits in a panel where the policy that he formulates is in issue. Okay, so he is the one who involved in the formulating the policy, and the policy becomes an issue. So he will try to solve the issue. He becomes the panel. So obviously decision later will affect. Okay, will make in favor of the policy tu lah, because he involved directly, right? Okay, the panel directly or substantially involved in the making of such a policy. Substantially maksudnya dia memang ada apa kita panggil meaning that the whole, okay, the whole policy, for example, right? So we have two cases to be compared here. First, we have Franklin against Minister of Town and Country Planning, 1948. Okay, in Franklin here, Franklin says that, okay, in this case, the minister becomes a panel, okay, because he wants to make a decision to confirm the public inquiry. Okay, so they argued that there was a policy bias in this case because the law required impartial considerations, and that in fact had not been given. Okay. They argued that the minister could not confirm his own made policy. They thought that, okay, he was a minister, he involved in making of that policy, so mungkin akan ada policy bias. Okay, so the case went through the High Court, then Court of Appeal, and then last at the House of Lords. But at the House of Lords, okay, the judges decided that the minister function was administrative in nature and not quasi-judicial. So actually in this case, when the minister confirmed the policy, okay, he is just exercise the his functions as administrative as in nature. Okay, so there is no issue of personal bias in this case. Okay, in Franklin there was no personal bias, but you may contrast with the case of Gulapalli Rao against Andhra Pradesh State Road Transport All Indian Report 1959. In this case, the secretary involved, okay, in making decisions for the policy, and the court held that the secretary could not do that because he was an integral part of the policy. Okay, and he was too much involved in the making of the policy, so he could not have an open mind in hearing objection against the scheme in question. So in this case, there was a likelihood of policy bias, okay, by the secretary. Okay, so there are three types of bias. Okay, and this should be last slide. Okay, exceptions of bias. Okay, even we learn the three types of bias: personal bias, pecuniary, and policy bias. However, okay, few exceptions granted. Okay, first is when the parties have been informed and they have expressly waived the right to challenge it. Okay, so the parties here refer to parties in the hearing. Okay, so they have been informed that maybe ada bias, but they expressly waive the right to challenge. So dia dah promise dia tak akan challenge kalau ada in favor decision pun. So accepted lah. Okay, and then statutes expressly provide for it. Okay, and necessity, no other person qualifies for that position. So tak ada orang lain yang expert yang qualifies, then it is necessary to appoint a panel that have a personal bias, for example, in the case. Okay, So I hope that you all understood, okay, what I'm telling you just now. Okay, so let's conclude together. For rules of natural justice, it is a process, okay, it is a procedure governed in making decisions. So if the authority fail to follow RNJ, meaning that the decision becomes void and becomes ultra biased and void. Okay, so there are two elements of RNJ: audio ultron patterns, okay, rights of hearing, and nemo judex in causa sua, rules against bias. So you must know the requirements of each elements of rules of natural justice, and then you boleh decide whether the accused may challenge or not the decision later. Okay. Alright everyone, thank you for your kind attentions. If you have any question to ask, please ask in our group's WhatsApp. Okay, I will respond to you. Okay, so do not worry, do not afraid I tak makan orang, so you can just ask me. Mungkin you ada certain cases you tak faham ke. Okay, this is very important because I cannot see you face to face. We will not have a physical contact. So through ODL, okay, we will do a meeting. Okay, maybe next time we will doing a Google Meet. Okay, Google Hangout for maybe, okay, in future, right? Okay, so please be safe everyone. Take care. Assalamualaikum.